Good evening. Welcome to Cambridge Forum. I'm Pat Zerke, the director of Cambridge Forum, and it is my great pleasure to welcome you this Constitution Day as we begin our 48th season of public forums in Harvard Square with one of the nation's preeminent constitutional scholars, Laurence Tribe, in conversation with Harvard Law School professor and author Randall Kennedy. Their discussion of the Supreme Court and the Constitution opens our program series this fall on the health of democracy. They, in effect, will be taking the first temperature to determine the health of American democracy and the idea of democracy around the world. Our forum tonight will be led by Randall Kennedy, the Michael R. Klein Professor of Law at Harvard Law School. His areas of interest are contracts, civil rights and civil liberties, race and the law, and the United States Supreme Court. He's the author of 6 books and numerous articles about the law, including The Persistence of the Color Line, Racial Politics and the Obama Presidency. His most recent book is For Discrimination, Race, Affirmative Action, and the Law. Professor Kennedy will introduce Laurence Tribe and our topic, and will open the conversation with Professor Tribe after his initial remarks. After their initial dialogue, he will open the discussion to you.
Welcome to Cambridge Forum, where we are going to be discussing the Supreme Court and the Constitution with Laurence Tribe. I'm Randall Kennedy, Professor Tribe's colleague at Harvard Law School. Laurence Tribe is Carl M. Loeb University Professor and Professor of Constitutional Law at Harvard University. In addition to teaching constitutional law for more than 40 years, he has helped write the constitutions of South Africa, the Czech Republic, and the Marshall Islands. He has argued dozens of cases in the United States Supreme Court, including the first argument in Bush versus Gore, and was appointed in 2010 by President Obama and Attorney General Holder to serve as the first senior counselor for access to justice. Professor Tribe has written scores of books and articles, including American Constitutional Law, the most frequently cited treatise on the United States Constitution. His current book, co-authored with Joshua Mott's Uncertain Justice, the Roberts Court and the Constitution, serves as the basis for our discussion. Welcome to Cambridge Forum, Professor Tribe.
Thanks, Randy. Thank you very much, Randy. I don't know how many of you know much of Randy Kennedy's truly distinguished work, but it is a great honor to be introduced by him and to be invited here to speak to you on Constitution Day. So, happy Constitution Day. H.L. Mencken once said, "For every complex problem, there is a solution that is simple, neat, and wrong." I think we can all agree that understanding today's Supreme Court qualifies as a complex problem. And the solutions offered in most of the current commentary on the court are just as Mencken predicted they would be: simple, neat, and wrong. Wrong, essentially because they're too neat and simple, reducing too much of the court's complexity and the justices' attitudes to caricatures of judicial restraint versus judicial activism, and to stereotypes of liberal versus conservative and left versus right, whereas the truth is in fact more subtle and more interesting. Getting it closer to right while avoiding legal jargon was the aim of my latest book, Uncertain Justice, which I co-authored with an extremely talented former research assistant named Joshua Matz, who incidentally began a 1-year clerkship for Justice Anthony Kennedy just after our book came out in June. I should say parenthetically, I've had enormously good luck in my selection of research assistants. They have included the President of the United States, Justice Kagan, and although John Roberts wasn't a research assistant, he was one of my most talented students. Some of the rulings that Joshua and I write about in detail, like the long-anticipated and still seriously misunderstood 2012 decision upholding the Affordable Care Act's individual purchase mandate in an opinion written by Chief Justice Roberts and joined by the 4 justices usually labeled liberal, frustrate both libertarians and those who believe in sharply limiting federal power. And yet the same decision, rendered on the same day, but in another opinion written by Roberts, but this time joined by the 4 justices usually labeled conservative, plus 2 of the 4 supposedly liberal justices, Justice Breyer and Justice Kagan, held that states are constitutionally entitled to reject the Affordable Care Act's expansion of Medicaid, and that Congress's attempt to make them either accept it or lose all Medicaid funding was unconstitutional. That was a ruling that seriously undercut the viability of the Affordable Care Act and joined the line of decisions frustrating egalitarians and believers in strong federal power to protect those whose needs are the greatest. Yet that 7-2 ruling rested on the very same set of principles that the court invoked last year in another Roberts opinion, striking down by a 6-2 vote with only the dissents of Thomas and Scalia, an act of Congress that required organizations fighting HIV/AIDS around the world to publicly condemn prostitution and risk alienating sex workers if they wanted to receive federal funding to help them combat HIV/AIDS. Understanding those principles clearly demands getting past the usual ways of pigeonholing the justices, ideologically or politically. So that's what uncertain justice tries to do. Equally misunderstood are decisions like the 5-4 campaign finance rulings in Citizens United and McCutcheon versus FEC. This year's McCutcheon decision in particular, which invalidated Congress's limit on the aggregate contributions individuals or corporations could make to political candidates or their campaign committees, even though the court had previously upheld limits on how much they could contribute to any one candidate, turns out to have rested on the same principle that explains the quite progressive 6-2 decision on behalf of the groups who sought federal aid to combat the HIV virus but didn't want to alienate sex workers. Now, it's a complicated story. I'm not going to tell it all now, but trust me or read the book, it's the same principle. The now 4-year-old decision in Citizens United continues to frustrate those, including me, who yearn for some way to reduce the role of corporate and personal wealth in our politics. But that case turns out to provide a powerful illustration of how taking a closer and open-minded look at what is really involved in empowering our lawmakers to enact their version of a level playing field for campaign speech can lead people, again including me, to reconsider their initial opposition to Citizens United and their initial agreement with the dissent, and to conclude with regret that Citizens United was rightly decided. Why don't you boo? You should boo. This is Cambridge. No, thank you for being open-minded. This court's down-the-middle affirmative action rulings continue to frustrate both those who believe that the time has come for government to become race-blind and those who believe that we're nowhere near having erased the stain of racism that defines America's original sin, and that only race-sensitive government action can ultimately get us beyond the tragic realities of racially insensitive and even racist policing in places like Ferguson, Missouri. To point to just one last example, the court's rulings striking down some gun safety measures while giving a green light to many others, and leaving up in the air issues about carrying weapons outside the home in public places, frustrate people at both ends of the explosive gun control issue. Now, I obviously can't guarantee that reading my book will replace all your frustrations with a sense of deep satisfaction and repose. But I do think it will augment at least some of your disquiet with a deeper understanding and a more realistic sense of what is likely to make a difference in our daily lives and what's likely to be dead on arrival, to provide pointless window dressing, or even to do more harm than good to the constitutional values that you probably believe in. Large part of our purpose in writing the book was to help both lay readers and lawyers see past the cardboard cutouts of the court and its individual justices, the ones that often dominate public discourse about the law and politics of the third branch of our government. It was important to us to identify the arenas in which this court has essentially become what I call an anti-court court. That is, to point out those places where the court's decisions are making it increasingly tough for ordinary citizens to sue bad cops, bum prosecutors, and dishonest businesses. Not because any of the justices has a perverse affinity for those defendants. Just give me some more bad cops, I want to help them. No, that's not it. It's because justices across the ideological spectrum, including some of those that you might classify as liberal, have a deep distrust of plaintiffs' lawyers, of lay juries, of inexpert judges, and of the whole structure of civil litigation. They have a greater trust for expert administrative agencies and for expert arbitrators. It's that set of attitudes, reflecting the justice's own experiences and backgrounds, that is leading the court to shut down class actions, enforce mandatory arbitration clauses that are presented to consumers in fine print on a take-it-or-leave-it basis, and immunize public officials and the cities that failed to train them adequately from civil liability. Along the way, the book challenges the conventional wisdom about the pros and cons of unanimous versus deeply divided decisions, identifying important values that are served by making the internal divisions within the court more transparent rather than reaching for surface consensus, or for what Dahlia Lithwick of Slate calls phononymity. We try to illuminate some of those internal divisions and their significance with backstories of justices poking fun at their ideological soulmates on the court and ending up making unexpected philosophical and legal alliances. You wouldn't know it to read most of the coverage of the court, but Alito and Scalia are at each other constantly, and occasionally either one or the other or both of them join hands with some of the more liberal justices to reach an intriguing result. Mostly, we try to shed light on what the future might bring. We show, for example, that Citizens United and McCutcheon and Hobby Lobby are not about treating corporations as though they were living, breathing human beings. That the main obstacle to effective firearms regulation is not to be found anywhere in the Constitution, and that to the degree the Bill of Rights does stand in the way of such regulation, it's less the Second Amendment than the First that is responsible. By bringing things like that to light, we open what we hope is a whole new universe of possibilities for moving the law forward. In the same spirit, Uncertain Justice undertakes to explode some myths. Myths about why, for example, Chief Justice Roberts cast the decisive vote to save the key provision of the Affordable Care Act using Congress's taxing power. Now, that was a vote that my approach to the court made it easy for me to predict publicly, and I did, on MSNBC, not on Fox, on a number of TV channels, at a time when most court watchers said Tribe is crazy. Perhaps he and all of the Harvard law faculty, Randy, should be committed. But it turned out that I was right. In many ways, I should tell you that 2014 has seemed a good year for everyone to invest some time learning and thinking, and in my case, writing and talking about the court's complex role in American life. It is, after all, the 60th anniversary of Brown v. Board of Education, whose promise of racially integrated public education has yet to be realized. It's the 50th anniversary of Gideon versus Wainwright, supposedly guaranteeing the effective assistance of counsel at public expense for all criminal defendants, but making a promise that our nation hasn't come close to keeping. It's the 40th anniversary of United States versus Nixon, the Watergate tapes case about a president who tripped himself up by surreptitiously recording his own Oval Office conversations, which makes it impossible not to think about the current president's use of government power to surreptitiously track not just what's going on in the Oval Office, but all the websites that each of the 300 million of us visits, and all the people each of us emails or calls on our cell phones. Brown, Gideon, and Nixon represent three huge milestones for the rule of law and for justice. But it's obvious that they are milestones on a long and unfinished journey. It's a journey that every law student, every lawyer, indeed every citizen, should come to regard as a personal, if not a professional, challenge. As the poet said, we all have miles to go before we sleep. Now, how winding and uphill that road will be in turn depends on something else about this year. It is the 10th year of the Roberts Court, a court with a mixed and misunderstood and, above all, uncertain record on an astonishing range of issues that matter to all our lives. And in Uncertain Justice, we try to take an even-handed look at all the major areas in which that court has been making waves or conspicuously failing to make waves and where it seems to be heading. Our methodology tried to show by example how remaining open to the arguments of people with whom you initially disagree can sometimes lead you to change your own mind, and how, even when it just reinforces the view you had at the outset, it can give you a firmer grip on what underlies opposed views and how you might more effectively combat them. This court seems to be on the precipice of a truly historic leap toward equal justice for members of the LGBT community. But it has made much less progress on gender equality and women's reproductive rights, with the fate of abortion rights in particular potentially hanging in the balance, and with decisions suggesting that even access to contraception, which lots of people thought had been settled as long ago as the mid-60s, can no longer be taken for granted. There's quite a bit of funny stuff in the book, including stories about the annual porn day at the Supreme Court's basement, where the justices actually watched porn and made constitutional law, one sex scene at a time. President Obama's deadly aim when he set out to target and kill an annoying fly. How a national narrative about a humble member of the cabbage family, broccoli, nearly hobbled Obama's signature domestic achievement, national health care reform, and the obsession of nearly all the justices with baseball and the complex role of the umpire. At bottom, though, the message of the book is a serious one. It's a message that should remind readers that not every legal battle in which justice is at stake involves a sexy issue like guns or money, or race or religion, or, well, sex itself. Some of the most important legal battles involve credit scams, or wage theft, mortgage fraud, or compulsory arbitration, which is why the book talks about the court's take on issues involving economic liberty as well as voting rights, drug prices as well as high school students joking about smoking weed, fees hidden in AT&T cell phone contracts, as well as government searches of our cell phones, and GPS tracking of our cars' movements, and the collection of DNA samples from everybody's stop for failing to wear a seatbelt. One of my favorite cartoons shows a sailing ship heading toward a distant shore. A guy on board scans the horizon and muses to his buddy, "My immediate objective is religious freedom, but my long-term goal is to go into real estate." You know, that could, of course, have been one of those endless lawyer jokes if the vessel looked more like a cruise ship and less like the Mayflower, and if the dude speaking looked more like a Wall Street lawyer and less like a pilgrim. Instead, that New Yorker cartoon was a reminder, to me anyway, that justice is a house of many mansions, that justice and injustice alike are to be found not only in pioneering impact litigation over high-voltage civil rights and civil liberties issues, but in every lawyer's everyday practice and every company's hiring and promotion policies and every citizen's willingness to stand up against spousal abuse and child abuse and to stand for decency and dignity for every individual. And the cartoon is a continuing reminder, not just to practicing and aspiring lawyers, but to everybody, that you need more than just a vessel to navigate in. You need a moral compass to navigate with. That can make all the difference between a life in any field that's worth living and a life that's a sad waste of talent, between a life that has a mission and a life that's just a series of business arrangements. But before I get too preachy, I want to turn the floor over to Randy, who is going to be conducting a conversation, and to all of you, so you can ask some questions that I will do my best to answer. Thanks very, very much.
You are listening to Cambridge Forum as we continue our discussion of uncertain justice, the Supreme Court, and the Constitution. Professor Tribe, in reading your book, I was really quite struck by the degree to which you're very generous and very gracious to the members of the Supreme Court, particularly the more conservative members. I mean, everybody knows that you're a fervent liberal, but in your book, you really you suggest that you hold in very high esteem the court itself, including its conservative members. Let me read you a line here. The 9 justices, this is from you.
Okay.
Quote, "The 9 justices practice their own form of politics, not the low and occasionally demoralizing politics of our endless partisan struggle, but a high politics of constitutional principle in which they compete to define the framework of our fundamental law." So there's electoral politics, which you talk about as sort of, low, and then there's judicial politics that you define as high. Well, I see the justices, all of them, as engaged in just plain politics. Why am I wrong?
Well, Randy, if you don't feel wrong after reading the book, what can I say? I guess it's the piling on of examples. Sure, Scalia is a conservative.
Bush versus Gore. Let's start with that one.
That's not one of my favorites, but I'll go back to Bush v. Gore in a minute. But let me just say, Scalia, great conservative, right? But he's more liberal than Breyer and, in fact, than anybody else on the court when it comes to things like thermal imaging to figure out whether you're growing some illegal substance at home, or than any of the justices when it comes to taking swabs of DNA from you in order to create what he calls a genetic panopticon. He's a conservative, but he votes that people have a right to protest the government even by burning an American flag. Alito is a conservative, but he makes fun of Scalia's originalism. In one case, he said that, "I think what Justice Scalia wants to know here is whether James Madison enjoyed video games." The justices just can't be put into these neat pigeonholes. Now, what I think is that by being generous and listening to what they have to say and not just saying, "Oh, I know how to type this one or that one," you actually learn a lot. You may end up still disagreeing with them. I still disagree deeply with what the court has done in a number of cases, including Bush versus Gore. But the fact that I disagree deeply doesn't mean that I think they're a bunch of political hacks in robes. That is, they have their theories, sometimes cockamamie theories, but they are theories, and they try to develop them. And I think we are better off, rather than us liberals preaching to the converted and saying a bunch of right-wing hacks, trying to understand them from inside, what it is that makes them tick. Now, it's true that occasionally I think the court really screws up. I do think Bush v. Gore was an example, but it was in some ways the exception that proves the rule. Because in Bush v. Gore, I think the court got it so deeply wrong that they really allowed their view of whose ox would be gored, as it were, Al Gore or George Bush, to influence what they saw. What they saw when they looked at the situation in Florida was 7 state court justices appointed by a Democratic governor conducting what looked like a chaotic recount, holding ballots up and all the rest, and they honestly thought this is chaos, whereas I looked at it and I thought this is democracy. But one person's chaos is another person's democracy. They wanted to bring an end to it. Now, how close can I be to confident that Sandra Day O'Connor didn't want to bring an end to it because she was tired of being on the court, her husband was ill, she wanted to resign, she didn't want Al Gore to replace her? That's the speculation of some, but I think there are other ways to understand it, and besides trying to develop a whole approach to an institution like the court from one gross case, I think doesn't help you very much, and that's why I think I gain more, and the readers of this book gain more, from trying to take a generous approach to what the court is doing, right and left.
Okay. I am very happy to be here, very honored to be here, I feel very privileged to share a stage with you, Professor Tribe, for a variety of reasons, but one reason is because you've not only been the most highly esteemed commentator about the Constitution and the Supreme Court over the past half-century, but you've also been a participant in our politics, our high politics. And one moment that really, the moment that I'm thinking about the most when I say that was your participation in the highly contested confirmation hearings involving Judge Robert Bork. You participated, you were very influential, you have paid a very high price for that participation. That's all a prelude to asking, what do you think about the confirmation process of justices? You've participated in them, you watch them very carefully. What do you think about the way in which justices are chosen and the way in which the Senate goes about confirming the nominations made by presidents?
I think the process is terrible. I think anybody who's half smart enough to be a justice and who is coached by the White House team that any given president is going to have has learned by now how to talk a lot without saying a single thing. I mean, some of them can do it in a witty way, the way Elena Kagan did. Where were you that Christmas? Oh, I was where all good Jews are. I was in a Chinese restaurant. She can put off people who don't really like where she's coming from. John Roberts, I just want to be an umpire. I don't want to pitch or bat. That was a perfect pitch, as it were. And the public loved it, even though I think we all know that unlike most umpires, these people actually make the rules. They make the rules by which we live on the basis of a constitution that barely specifies any of them. Besides, there was one famous umpire who said, you know, the strike zone is a living, breathing document. And I was giving a talk about the book in San Francisco, and a guy comes up to me, he says, I'm a lawyer now, but I used to be a pretty good umpire, and I don't know if you know about Rule 9.04C of the Major League Rules of Baseball. And I said, no, I'm afraid I don't know about 9.04C. And he read it to me. That rule says that the chief umpire has the authority to rule on any matter not covered by these rules. And that's pretty much what any chief justice or any justice ends up doing. If it's easy enough to be covered by the rules, you can, you wouldn't need to get all the way to the Supreme Court and have 9 bright people making the decision. But the process doesn't give you a clue what these people are really like. They can all be coached to say, oh, I can't talk about that. That might come before me. I mean, it sucks. It doesn't tell you anything. What we need to do is ask ourselves, what kind of stuff did these people write in high school and college? What were they like to the person down the street? What kind of experience did they have? Did they have the kind of experience that will lead them to think that litigation is not worth anything and that we all need to rely on experts? It's the backgrounds of these people, and it's on that basis that the current court is not nearly as diverse as perhaps it should be. The court that decided, I'm sure you know, Randy, Brown v. Board, the court that decided it, didn't have previous judges. It had governors and attorneys general and the chairman of the SEC, whereas now we have a bunch of people who are brought in from the farm teams, especially from the U.S. Court of Appeals and the D.C. Circuit. They don't have the breadth of experience that I would like to see. So I think that a more plausible confirmation process would be one that emphasizes not what they say when they're basically talking like trained seals or putting on a kabuki performance, but what their lives have been like, and pay attention to that and not say that's off limits, because all we want to know is their IQ and could they judge according to the law. Well, they're making many parts of the law. Of course, all of them believe they are judging according to the law. None of them will say, by the way, I'm just judging by the seat of my pants. So I think it would be much better if the process were different. How precisely to change it, I don't really have a formula.
Mm-hmm. What do you think of life tenure? Mm-hmm. I mean, people live longer now, and the world changes more quickly, it seems. I suppose one argument in favor of life tenure, of course, is to ensure the independence of the judiciary. But what about some other mechanism to ensure the independence of the judiciary, as opposed to the risk of having someone up there for such a long, long time and maybe being out of touch with their society? What do you think of life tenure?
Well, I think one thing that helps them stay in touch is the young law clerks that they keep getting. So that, for example, the recent opinion by John Roberts about how the police can't search your cell phone when they stop you at a traffic light, that was so filled with high-tech stuff about Faraday bags, and there's an app for that, that you know that either he is much more savvy than even the typical 50-year-old, or that he listens to his law clerks. But they can get out of touch, and they can become kind of decrepit. And the question really is whether we should have that system to guarantee independence. There are other ways, and I think that when our system got going and when the average life expectancy was decades less than it is now, life tenure may have made more sense. Right now, I would favor a system that basically gives judges an 18 or 20-year non-renewable term. They're not going to try to please anyone because their term can't be renewed. You might have to amend the Constitution to do that, but you probably wouldn't even have to amend the Constitution. Because the Constitution only says that these judges serve for life. It doesn't say where they serve for life. That is, there's Sandra Day O'Connor and John Paul Stevens and David Souter serving on lower courts now that they've retired. You could have a justice retire, serve on courts of appeals, and when the court is divided 4-4 because someone is recused, instead of having a gap and possibly an evenly divided court, you could call in one of the retirees and say, sit on this one, sit on that one. I think that would be a better system.
Okay. You're listening to Cambridge Forum. I'm Randall Kennedy of Harvard Law School, speaking with Professor Laurence Tribe. Let's take some questions from the audience. Please come forward and line up at the microphone. And when you come up, make sure that you ask a nice, crisp question. We don't want to filibuster, but the floor is open. And so please come if you'd like to.
I myself am a lawyer, but I will strive to be brief. You, Professor Tribe, you, I guess, you sort of endorsed Citizens United, but what concerns me is there are two forces here that are coming together, I think, in a negative way. One is the Supreme Court's relaxation or elimination of limits on political contributions. And at the same time, our society is experiencing an ever greater inequality of income and wealth. And it seems to me those two forces coming together are a kind of perfect storm of reducing democracy. More and more power is in the hands of fewer and fewer people. What is your response to that?
Well, first of all, I very much agree that the problem of maldistribution of wealth is probably the biggest problem we face, perhaps other than climate change, in terms of a disaster for our society. If I thought that sacrificing what I regard as a very important First Amendment value of not giving government the power to decide who can say how much to whom, if I thought sacrificing some of that could get rid of much of our inequality, I would be more open. And I have to tell you, when I first read Citizens United, I was much more persuaded by the dissents than by the majority. But the more I thought about it, and the more I studied, and the more I read the opinions, the more I saw a few things. First of all, it's not as though the Supreme Court could, in some way, or even Congress and the states, by amending the Constitution, could equalize things. All they could do is hand a blank check to Congress and say, you pass some campaign finance reform. Now, that means handing a blank check to the people that most of us think are already bought and paid for, and that many of us don't trust. It means handing them a check that they can fill out in a way that makes it harder for anyone to topple an incumbent. It means giving them the power to regulate elections, but no power to regulate general lobbying. That is, it's a Band-Aid, not likely to do much, but likely to give people the feeling that they have done a lot. And the more I thought about it, the more I thought it's not worth giving up a basic First Amendment principle for that feeling. And why do I think it's a basic First Amendment principle? Well, take the facts of Citizens United itself. It was a corporation. They published this expensive, slick, anti-Hillary documentary. And the question was whether it cost so much that they exceeded some spending limit. Well, suppose, and this question was asked from the bench to people, suppose it was an anti-Romney group or an anti-some other group, and they publish a book, a really expensive, fancy, glossy book, and someone says, that book costs too much, you put too much money into it. And come to think of it, the New York Times spends an awful lot on its editorial page sort of expressing opinions about who should win and who should lose. Once we start giving Congress the power to begin tuning this down and tuning that up and essentially orchestrating speech, we will have given up a great deal. And in my view, we will not have accomplished nearly enough. Now, there are other approaches, much more massive disclosure, so that you say this is the ad brought to you by the Koch brothers, or this is the ad brought to you by Sheldon Adelson. And it's not only corporations, it's rich individuals as well. I think that would help. I think much more public funding would help. But I think the idea of giving Congress the power to regulate either contributions or expenditures is a Band-Aid that would give up too much by way of First Amendment principle for too little progress by way of equalization.
Thank you.
Thanks.
Professor Tribe, my name is Ben Bolger, and I understand that you were born in Shanghai, China. And so I have a question about the topic of immigration. That's certainly an ongoing debate. Constitutionally, it seems that there's two classes of Americans, those that are born here naturally and those that immigrate. And not everyone is able to run for the presidency. And I'm not suggesting that I suggest that Arnold Schwarzenegger should run for the presidency, but I'm wondering, from a theoretical standpoint, if someone becomes...
What about Ted Cruz, who was not born in the United States?
If someone, such as yourself or whoever, is born abroad but goes through a legal process and becomes an American, shouldn't we have one class of a U.S. citizen? Does it still make sense in today's modern society to have a bifurcated class of that kind?
I don't think it does. I think the provision saying you have to be a natural-born citizen to run for president or vice president is antiquated, bizarre, serves no purpose. I think it would be hard to energize the American public to get rid of it because justly and rightly, the Constitution isn't easy to amend. More than 2,000 amendments have been proposed. Only 27 have ever made it through the whole process. And a lot never get proposed because people know how hard it is. Basically, all the amendments that have made it are either amendments that broaden the franchise or are crazy ones that get reversed, like prohibition, the 18th Amendment reversed by the 21st Amendment, or are technical fixes to a terrible problem. Like there was a terrible problem of the president getting sworn in at a time of year that didn't work, didn't make sense. But this particular problem, I just don't think is likely to get fixed, so we live with it. The universe of people who can become president is arbitrarily shrunk. Not good, but nothing is perfect.
Thanks very much.
I think you said that you think the court is on the verge of another historic ruling regarding the LGBT community. So you know I have to ask what you think the next ruling with respect to marriage equality will be, and if it will be different from the last one. Why?
Well, it certainly will be different because the last one, Windsor, only struck down a provision of the Defense of Marriage Act, which which basically said that if the state says same-sex couples can marry, then the federal government has no business denying them federal privileges, really more than 1,000 federal privileges. It was a kind of marriage, as it were, of liberty, equality, dignity, and federalism. That is, the court was saying this is not something for the federal government to do. And when, as I predict, the court will take the next step, which will be to say that no state can deny same-sex couples the right to marry. Justice Scalia, in his dissent, will say, last time you talked about federalism. Now you're having a federal institution, the U.S. Supreme Court, interfere with state law in an area that's always belonged to the states. And Kennedy, who will write the majority opinion, will respond, well, we always interfere with what states do or what the feds do when we think there's a fundamental human right at stake. That's what we did in Loving against Virginia, probably the best-named Supreme Court decision ever, when the court in 1967 struck down the laws that banned interracial marriage. And when it did that, the country was not necessarily all ready for it. That is, there weren't that many states that banned it. Now there are still more states that ban same-sex marriage, but 70% of the American people thought that it's okay to prohibit interracial marriage. So in this case, the court isn't going to be getting very much far ahead of the public. And why do I think it'll do that? Well, every single court, almost 20 now, since Windsor, has seen the logic and has said it can't stop where the court stopped. Even Scalia, dissenting in Windsor, said, I think everybody will take this the next step. It's logically unavoidable. And that dissent, of course, will be quoted against him by Scalia, by Kennedy in the majority opinion taking the next logical step. I think it's quite inevitable. I mean, I don't have a crystal ball, but there are 7 cases now pending. The court is going to be voting, at least initially, on September 29th at its big conference on which of them to take. It will probably hear argument in at least one case that involves marriage being transported across state lines. Can a state deny treatment as a married couple to a couple who was lawfully married in a state that recognizes same-sex marriage, like Massachusetts or New York? And then it will have a case that squarely deals with same-sex marriage, yes or no, by a state that tries to ban it. Now, I don't think it's absolutely certain the court will take this step, but I'd say it's about 80% certain.
Carol Agate, the lawyers are trained to be advocates, to take one side or the other. Lawyers become judges. Have you ever thought in terms of a judicial system that has separate training and a whole career path for judges and for lawyers, so that judges start out at the very lowest level, administrative law, work their way up, and they're judged on how well they are as being unbiased, rather than having judges on the 2 extremes, 2 extremes appointed by parties, so that we try and get a balance by having both kinds, and then the court goes whichever way the parties happen to wind up appointing them.
Well, the system that you describe is what's used in many European countries, where judges are selected from a kind of civil service. They are trained civil servants. They are largely technicians, as opposed to being either powerful advocates or politicians, or a combination of both, as the court that decided Brown v. Board was. But it seems to me that in a system where we put the deepest, most fundamental issues about how people should be allowed to live their lives, questions like same-sex marriage, or questions like, should you be able to have a gun in your home, or should you be protected from guns in the shopping center, really basic questions. A system that puts those fundamental questions to its highest judiciary, rather than kind of narrower technical questions. Questions on which the nation is bound to remain divided, questions about abortion, questions about the right to die. I think for that system to select judges from a special, separate track of elite people who are supposedly unbiased doesn't make a lot of sense. I mean, what does it mean to be unbiased? There's one aspect of John Roberts' image of the umpire that I do agree with, and that is the one thing that judges should not do is vote for this side because they want this team to win the pennant. That is what people suspect the court did in Bush v. Gore, that there may have been 1 or 2 who saw the arguments the way they saw them because they wanted Gore rather than Bush to be president. Now, I have a whole fancy theory about why that probably doesn't explain Bush v. Gore, but I won't bore you with it now, and I assure you it's not in the book. So don't worry about that. But it seems to me that in that sense we want judges to be unbiased. But do we want them not to have preconceptions about what is right and what is wrong? Scalia once said, and I think he was worth quoting to this effect, that a judge who really comes to the court as with a blank slate, not having deep views about issues like dying and sex and abortion and guns, is somebody not worth having on the court, because if you're serious, you will have thought about these things for a long time, and you will have formed at least tentative views. So picking judges through a kind of civil service system, though it may have some surface appeal, I just don't think would work in our country. Mm-hmm.
There was a story in this Sunday's Globe on highway interdiction and asset forfeiture that I found a little bit disturbing. And when I looked into it, it led me to a case, Bennis versus Michigan, that when I looked at that, I found that one disturbing too. When I looked at the majority opinion there, it's the only justification for their ruling seemed to be we've always done it this way. Mm-hmm. And while I understand you don't want to revisit all the 5-4 cases anytime you get a new justice on the court, because it's too unstable, I just don't see any other justification for what they did. So my question is, what are your thoughts on highway interdiction? on the Bennis case, and if they're, I assume they're different from the court's ruling. Assuming they are, can you explain to me how they ruled the way they did in that case?
Okay. Well, I have to admit, I didn't read the thing about highway interdiction. I do vaguely remember Bennis, which was a case in which the car belonged to the woman or the man, and it was the person's partner who allegedly did something wrong, but the car was completely confiscated, notwithstanding that. And I think it was Justice Thomas who dissented, didn't he? Or I'm not sure.
Well, Ginsburg and Scalia were in the majority.
And I think, well, whatever it is, that decision, it disturbed me as well. I mean, what the court has said is that there are certain clauses in the Constitution, like the ban on excessive fines and ex post facto punishments, that have a kind of technical, narrow meaning, unlike words like free speech and due process, which invite people to think about an evolving and living Constitution. And when it comes to the ones that have a somewhat narrower, more technical meaning, like the provision about the right to a civil jury in certain cases, the courts tend to be much more stuck on the history, saying that if we don't give those words the kind of the meaning they originally had, then there's just no constraint. Take a word like assembly, peaceful assembly. Justice Douglas, when he first wrote the first draft of the case saying that married couples have a right to use contraception, tried to ground it on the right of peaceable assembly. He said, we're assembling perhaps body parts. And Justice Black blew up and he said, I don't know about you, but when I have sex with my wife, I don't think of it as peaceful assembly. And I think that certain words, or domestic violence, the federal government has to protect states from domestic violence. Now, today we talk about domestic violence, and we're thinking about these football players who are abusing their kids or abusing the then fiancé, but surely that's not what domestic violence means in the Constitution. So what probably explains Bennis is that the court had an agreement across ideological lines that this was a problem that was handled by a specific, rather technical part of the Constitution, for which civil service kinds of judges who are trained to read technical language might be just as good.
Thank you.
Thanks.
Well, we expect our Supreme Court justices to be...
You have to talk up a little. Okay. I'm not sure they can hear you.
Yeah, we expect our Supreme Court justices to know the Constitution well and to be fair to both the corporate and public side. But you brought up the thing about having a judge who is biased. But what about the case where one of the justices knows one of the defendants or one of the people, like for instance in the Gore versus Bush case, where Justice Scalia knew the vice president, and there was a particular friendship between the two, and he would not recuse himself from that.
Yeah.
There doesn't seem to be any sort of mechanism for someone to be removed from a case on the Supreme Court. Is there something there that there is some sort of a mechanism, and also is there a mechanism in other courts in the United States?
It's usually up to a judge in any court to decide whether or not to recuse himself. There are often ethical standards, but the Supreme Court has so far said we set our own standards. Now that's probably not so good. They ought to be pressured, at least shamed, into developing more rigorous criteria. Right now they all tend to recuse themselves if they own stock in one of the companies that is before them. But the criterion you mentioned, knowing one of the parties, my God, you don't get to be a Supreme Court justice until you know almost everybody in public life. So that it'd be a court of 0 justices. In Bush v. Gore, all 9 justices knew Al Gore and George Bush. And as far as I know, they actually all like both of them. So what are you going to do about that? It's often the case that people argue before the court. I mean, I argued before the court, and one of the justices was Justice Stewart. I had been his law clerk. People argue who clerked for Kennedy or Kagan or Roberts. I think you've got to be able to trust the justices to at least set that aside. I mean, they care about their long-term reputation. Are they going to sacrifice it, just because they like this guy or dislike that one? When the Affordable Care Act was being debated, people said that Elena Kagan should recuse herself because she had been my research assistant, and she was Solicitor General when I was Senior Counselor for Access to Justice, and someone found an email from her to me saying, "My God, Larry, it looks like they actually passed this thing." And somebody said, well, that must mean that she is biased in favor of the Affordable Care Act. Well, she was one of the 7 justices who voted to strike down its vital Medicaid provision. And then they said Clarence Thomas should recuse himself because his wife earns money from some of the right-wing groups. I mean, there's just no end to it. I think it's much better to trust them subject to an ethics code that ought to be more fully articulated. Thanks.
Hi, thanks. Speaking of climate change, the president is trying to do what he can through the executive branch, and the people are taking to the streets this Sunday for the People's Climate March in New York. And the Supreme Court, of course, came through with Massachusetts versus EPA. But can you think of any angles or overarching ideas that we could bring through the judicial branch to actually make, stronger action on climate faster?
Well, in our system, the judicial branch sits to review the political decisions of the other branches. It's not an engine of political change. There are other systems in Israel and South Africa where the highest court has a more activist role, but it would be a veritable revolution for our court to really do much pushing in that way. What it is a kind of break. It's a break on some sweeping reform. What it can do, and it has done that in a case like Massachusetts versus EPA, is say that an agency is being too stingy in interpreting the mandate it has been given by Congress. It does have the power to regulate greenhouse gases. Now, exercise that power. That much courts can do. And there are a number of cases in the pipeline in which some agencies are taking, perhaps because of industrial influence, perhaps because of their technical views of the matter, are taking a very narrow view of their clean air, clean water, and other kind of ecosystem mandates, where courts really can do a little nudging, but they can't really initiate. I mean, if the real long-term solution is more solar energy or more geothermal or something else that really requires a policy change, unfortunately, it's the one most paralyzed branch, Congress, that you really have to push. Now, there are things the president can do just by executive order. Ironically, he's being sued by the U.S. House of Representatives for slowing down the law that they tried 50 times to repeal. Good luck with that one. They probably don't have standing. They're not going to get anywhere. But as soon as the midterm elections are over, he's going to take some powerful executive actions, I think, on immigration. And the president does have some serious power not to deport the dreamers or to delay the deportation of their parents. When he exercises that power, you can be sure that a lot of members of Congress are going to object. They're going to say he's being imperial. But the court has already, in a case called Arizona versus United States, upheld the power of the president to withhold enforcement and struck down an Arizona law that took a much more aggressive approach toward show me your papers kinds of legal enforcement. And that was one where Kennedy wrote the majority opinion. Scalia was quite apoplectic in dissent. He said it's not up to the president to not enforce the laws. He has the duty to enforce them. But a strong bipartisan majority, if you want to look at the party that appointed them on the court, was with Kennedy on that, including Roberts and Sotomayor.
Thank you.
Mm-hmm.
I would like to ask you to talk about a recent case that you haven't discussed yet, and that is the Hobby Lobby case. Mm-hmm. And how do you interpret that vis-a-vis the First Amendment right to freedom of religion.
Sure. Hobby Lobby, I'm sure many of you have heard of it, but you may not know exactly what it was. Basically, the Supreme Court decided that when you've got a neutral general rule, like a rule saying don't smoke dope or don't imbibe peyote, the First Amendment does not give anybody the right to get out from under that rule just because it interferes with their religion. That position offended a huge majority in Congress, and Congress passed a law called the Religious Freedom Restoration Act that changed the law and said that in both state and federal contexts, when the government does impose neutral requirements on people, like the Obamacare requirement that large employees provide full spectrum health insurance for their employees, including contraception, that burden should not be imposed on people who have a sincere religious objection if the government could achieve its purpose in some less burdensome way. And in the case of Obamacare, the allegedly less burdensome way was to have a third party, like the government, cover contraception for the employee when the employer thinks, by that employer's own religious lights, that its complicity in having this provided, in this case Hobby Lobby was a family-owned huge company with lots of employees but very few shareholders, they thought that for them to be in any way complicit with the provision of contraceptions, some of which they viewed as causing abortion to their employees, was burdensome, and they said, you've set up a system in which we don't have to provide it. Somebody else can. And that was not a very powerful argument because the somebody else who has to provide it would either be the insurance company, which might say, you can't make us provide it free, or the government. And the government is not about to start paying for a lot of stuff easily. You'd have to get Congress to appropriate the money. On top of that, the question was whether the Religious Freedom Restoration Act applies to corporations. Hobby Lobby was a corporation. The history was ambiguous, and I think the dissenters had a very good point that corporations don't have religion within the meaning of the Religious Freedom Restoration Act. But the majority, in an opinion by Justice Alito, said, yes, they do, and we're not interpreting the Constitution. We're just interpreting what Congress did. So Congress could change it. Congress could amend, for example, Obamacare, to provide that it overrides the Religious Freedom Restoration Act and that the Religious Freedom Restoration Act doesn't really apply. It gets very technical, but also it gets very hairy because the suggestion in Alito's opinion that it's okay, the government can pay for it, was a suggestion that 3 days after Hobby Lobby, the court seemed to take back. In a case from Wheaton College, which also has religious affiliation, the court said that even making this was a preliminary ruling, they haven't finally decided Wheaton, even making the religiously affiliated college fill out a form to make sure that the insurance is covered by someone else might make them too complicit in what they see as religious evil. And Justice Sotomayor, joined by Justice Ginsburg and Justice Kagan, wrote a dynamite dissent saying that usually you can take this court at its word when it says something, but here, 3 days later, it's clear that you can't even trust these guys. Very rarely do they get that personal. So Hobby Lobby is a decision which I think is quite troublesome and unsettling, but people who fear that it will also mean that anti-discrimination laws cannot be enforced against religious bodies are probably wrong. That is, people who think that the president's executive order saying that contractors who discriminate based on sexual orientation are not going to get any federal money, that can be challenged by contractors whose religion tells them that gays are committing a sin. I think that's wrong because the government's compelling interest in combating discrimination can't be met in some less restrictive way. There is no third-party payer who can solve the problem of employment discrimination in the same way that might have been done with contraception.
It sounds a little scary. Thank you.
Thanks.
Professor Tribe, thank you for being here tonight and sharing your thoughts. I have not read your book yet, although I understand Uncertain Justice is available now at bookstores. I don't want to put words in your mouth, but several points tonight, the gist of your argument seems to be that there are, for every bad decision that the court may issue, bad in our opinion, that there is an alternative history that could have been written where the people came together either directly or through their representatives and engaged in some real forms of dialogue and deliberation and arrived at decisions that would obviate the need for the Supreme Court to even address some issues. Now, that certainly wouldn't be every issue, but it seems certainly in a lot of the issues, social issues, that could have been the case. So as a person who's spent a lot of time thinking about these issues, I'm just curious to know how you think we can make our democracy more participatory and foster dialogue and deliberation locally and then nationally.
Well, it's a very important question because I think that's where most of us can enter the picture. I mean, not everybody writes briefs in the Supreme Court, and much of what happens doesn't really depend on the Supreme Court. Let me take the example of guns. I mean, with respect to guns, all the Supreme Court did, and it was admittedly controversial, was to say that if you read the language carefully and look at the history, and this was true of both the majority by Scalia and the dissent by Stevens, although they read the history differently, you'll see that there is a right on the part of individuals to possess guns. But that right is subject to all kinds of regulation. And the court is so generous in the kinds of regulation it's likely to uphold that the main obstacle is political. So that getting together politically, in Massachusetts, there isn't that much you can do, but you all have friends in other states which are less liberal. Getting together politically and making gun safety a voting issue, the way people make gun rights a voting issue, saying, I don't care how good you are on other issues, if you're not going to vote for universal background checks, I'm going to defeat you. The way the gun lobby says, if you do vote for background checks, we're going to defeat you. That would make a difference. Now, actually, when I was writing another book called The American Constitutional Law, I concluded that there was this right of individuals to possess guns, but it could be well regulated. And as soon as that came out, I mean, liberals saying there's a right to own guns, no. There was a front page story in the New York Times saying liberal tribe is an apostate or whatever. And then the very next day after that, I get this call from a person with a very deep voice. Hello, this is Charlton Heston. And at first I thought he was kidding, but he clearly was not. He said, I'm delighted that you've come over to our side. I have a Gulf Stream waiting at Logan Airport and a little island that I could take you to, and we could plot together. He didn't say plot. We could make plans together. And I said, whoa, wait a minute. You know, I'm a great admirer. I loved Planet of the Apes. But we are not on the same side on this issue. I remained then and remain now on the side of political dialogue, making a political grassroots difference, even when that's not a way to change the court, although over time it is a way. I mean, the court does listen over time to the public. It's not isolated in some bell jar. These guys read, you know, they go on the internet, they surf the web, they watch TV.
Thank you.
Okay.
Thank you again for speaking to us tonight. It seems to me that in your approach to history, or the history of the Supreme Court, you operate under the assumption that the Supreme Court justices are moral individuals, that they have certain biases when they enter office. And I think obviously that's a realistic assumption when approaching history, but how can we justify that the arbitrary nature of the Supreme Court in terms of judicial review in a democratic system like ours?
Well, when you call it arbitrary, that's kind of question-begging. Our system is not purely democratic or purely majoritarian. There was a wonderful opinion by Judge Posner, who is often very conservative, appointed by Reagan, but he recently, on I think September 4th, held that same-sex couples have a right to marry no matter what the state law says. And he said that we are told that this is arbitrary and anti-majoritarian and anti-democratic for us to declare this. Yes, in a way it is. But majorities have run roughshod over minorities throughout our history. And when the minorities object, that's called constitutional law. And there would be no law of the Constitution if it was all a matter of just counting noses and counting votes. So the way, it's a long story, but the fundamental way I justify it is not the way some people do, saying, oh, the court just follows the election returns, it does what the people want, just give it time, it'll catch up. It often stands against what the majority wants. It often does what lots of people find objectionable, as it did in Loving against Virginia. But when it does that, hopefully it's doing that from the perspective of an independent bunch of judges who don't have anyone to please, don't have to get reelected, don't have to get reappointed. And even though we may not agree with their way of reading the Constitution, comparing that to a system in which the majority always ruled, that's a comparison that for me, it's easy to say I prefer the current one.
Thank you.
These are our last two questions.
Thank you, Professor Tribe. Excuse me. I found your comments on Justice Scalia and Alito and others on the conservative wing quite interesting and provocative. As I hear you describe them, they have views of the law and the Constitution. They have theories that motivate some of the decisions to which I and many others object. I guess I'll have to read your book, which I will, in order to understand those better. My question is, if I read your book, when I read your book, will I also discover the hidden genius of Clarence Thomas?
Well, you say it's hidden because he's so silent on the bench. When people ask him about that, he says, look, I was brought up to believe that when people are talking, you should be quiet. And none of the other 8 justices feels that way. That is, they barely let you get a word in edgewise. They've got a practice where they don't really discuss the cases before the oral argument. And so that's their one opportunity, even if they're using you as a punching bag, to talk to one another. And to have a justice who's actually trying to listen to what you're saying isn't always all that bad. Now, I know from talking to the justices and the law clerks, and not only Thomas's law clerks, that he's very talkative in conference, that he has plenty to say, that he understands the cases really well. And I do talk in the book about some insights that he brings. For example, on affirmative action, where I strongly disagree with him. I agree much more that we need race-sensitive methods of making choices for a more diverse society. And that the main purpose of the equality principle is not some abstract neutrality that we should be blind to color, the way Stephen Colbert says, you know, people tell me I'm white, but I don't know. I don't know anything about race. I think the purpose of equal protection is to avoid stigmatizing and subjugating and subordinating groups of people. And then Clarence Thomas says, yeah, but you don't know how stigmatized and subordinated I felt at Yale when everybody said, that's an affirmative action baby. I mean, he could ace his exams when they were blindly graded, and everybody still said, you haven't earned it. Now, Sotomayor is also a product of affirmative action, doesn't see it the way he does. But in the dialogue between his concerns about stigmatizing people through taking race expressly into account, and her view that you've got to do that in order to get past where we are now, that's a productive dialogue. I wouldn't want a court with 9 Clarence Thomases or one with 9 Sonia Sotomayors.
Thank you.
Mm-hmm.
Thank you very much. Going back to Citizens United, a question about the dissent, which I love the dissent. I think it's a great critique of Citizens United. Former Justice Stevens argues that there are multiple legal errors in the majority decision, like just flat out legal mischaracterizations of the scope of the anti-corruption interest. A flat out mistake by the majority that it's alien to the First Amendment to differentiate between speakers based on identity even though we do it all the time, children versus adults, prisoners versus non-prisoners, print media versus broadcast media. There are 101 identity-based distinctions under the First Amendment. So putting aside the ultimate policy question of whether we're comfortable or not with Congress balancing the First Amendment interests, isn't Justice Stevens correct that there are like multiple, like just basic legal mistakes in the majority decision, including the statements about we don't do identity-based distinctions, the statement that the...
I understand,
yeah,
but
okay.
given...
Thank you.
Short answer, no, I do not think Stevens is correct. Now, if you read the book, you will see that I agree with him on some points. Take, for example, the anti-corruption. That's much more important. I think in that particular point, Stevens is right, the dissenters are right, the majority is wrong, on the question of whether the government has a legitimate interest, not just in preventing quid pro quo corruption, bribery, it's already illegal, but in dealing with the problem of differential access. I mean, everybody knows that the tendency of a politician when elected to office to answer the phone and pay attention to someone's views is going to be affected by whether that person bundled hundreds of thousands of bucks for that politician. And when the court says that there's no corruption problem, I'm very critical of that statement in the book. I explain how, nonetheless, I think the court's bottom line was right for different reasons. As to the other points you make, a number of the things that Stevens says are just flat wrong, I think he's flat wrong about. You know, we can have a difference of view. It's true that he had a vote on the Supreme Court. I've never had that vote. Right now, we each have 0 votes, and I'm entitled to say I think he's making a mistake. And I've written about why I think it's a mistake. But, you know, this is not a kind of technical back and forth. It's quite possible that I'm wrong, but the point of view that I'm trying to describe in the book, namely that the problem of economic inequality and its baleful influence on our politics is much too deep to be solved by some of these Band-Aids, and that there is a powerful doctrine saying that you don't make any First Amendment sacrifice unless you can show it will be really efficacious in getting to the heart of the problem being solved. I think that's a very important point. When you read the chapter, you'll see that I'm very critical of Citizens United. You may not even be able to detect that I think it was rightly decided, but between the lines, I think that's the bottom line. But I certainly disagree with a lot of what the court said and a lot of its reasoning.
As a former student, thank you. I'm still inspired by that class all the time.
Thank you.
Thank you.
Professor Tribe, thank you very much.
Thank you, Randy.